For the ICC, the danger is not that Netanyahu remains free. The danger is that the court's enforcement logic is now legible. Observers don't need leaked cables to see how this works. They can watch the planes move. They can compare the routes. That's enough to infer how power interacts with law inside the system. When enforcement becomes predictable along geopolitical lines, all legitimacy just drains away. And this has consequences beyond Israel or Palestine. States currently cooperating with the ICC can see that the burden of cooperation is not being shared equally. They can see that embarrassment is tolerated when it falls on them, but avoided when it would land on European governments or their allies. That knowledge changes behaviour. It weakens incentives to comply, and it does so in ways the court cannot easily reverse once trust has been lost. This is the cost of doing nothing. Silence is not neutral. Silence creates precedent. When overflight permissions are granted repeatedly without consequence, that practice hardens into expectation. Future suspects learn the lesson. Future states internalise the message. And the next time the court attempts to enforce a warrant against a less protected individual, it'll do so from a weakened position. But what makes this worse is that alternatives existed and have been deliberately not used. Overflight permission is discretionary. Legal clarification could have been sought. Parliaments could have scrutinised executive decisions. None of that required confrontation or arrest. It required friction, rubbing somebody up the wrong way. And friction was avoided because they didn't want that. That avoidance wasn't caution, it was strategic though.